Okay. Hi guys. Okay, like I said I was having this cybercrime law exams that it requires me to know majority of the sections. As a law student, you need to grasp majority of the section. Normally in court, you don't you have to read your sections your from the act or law of which you're stating from. It's normal in court. You can say it out, you can still, you have to read it, so to be that you're reading it directly from the book itself, not just from your head. You may know it, but it's still advisable you read it, not to cause not to misinterpret it in your own terms or in your own words, not to paraphrase, but to state everything in accordance to what was written. So I just want to go ahead and start mentioning the offenses of which I've been able to grasp from the Cybercrime and Prohibition Prevention Act 2015 as amended 2024. Then the offences were stated from section 5 of the act to that of section 36 of the act, of which I said before that I only decided to store 25 offences out of 31 offences. It's actually from section 5 to 36, which is 31 offences. Then I decided to just store 5 and sorry, I decided to store 25 and penned the remaining 6, of which I said I was not going to use during my exams. I was not going to use those other 6 offenses because they are not really relevant for my scheme of work as at this semester. Probably for next semester I may decide to store the remaining 6, but for the semester which I'm trying to quickly grasp. Understand? I'm a transfer student. I was transferred to the faculty of law from the faculty of arts, where I was studying in the department of English and literary studies. So luckily I applied for the transfer and I was accepted for the transfer based on the CGPA you get. As long as you're making your CGPA from 4.25 to the 5 points, you can be transferred by the grace of God. So yes, I was transferred directly to the 200 level. So after the transfer was successful, we were not having the semester has already gone too far, so we, out of let me just say 4 months of the semester, probably what we were given was 1.5 of the month in order to understand the entire courses, and we are to offer legal method and English for legal writing from the 100 level. Then the courses for the 200 level were just 6 courses, making it a total of 8 courses. So like this, I'm having my exams soon. Just after this week. It's already Thursday and I'm trying to understand all the courses. So I just want to make this video for this particular cybercrime, of which I'll be writing as my first paper. And the exams are straight in a row. You write today, you write tomorrow, you write the next day after the tomorrow. That's how it is. You don't have it's not like other exams or other departments where you're giving grace to read for extra 2 days or 1 day. 1 day. It's not like that over here. So let me just start by making mention of each of the offenses that I've been able to grasp. So offense section 5. Offense section 5, it talks about offense against the critical national information infrastructure. Offense number 6, section 6, unlawful access to a computer. Section 7, registration of cyber cafe. Section 7 sub 2 talks about electronic or online fraud. Sorry for my slip of tongue. Electronic or online fraud. Then section 8 talks about system interference. Section 9, of which I did not store. Number 1, one of the offenses I did not store. Section 9 I did not. Then section 10 talks about tampering with critical infrastructure. Section 11 talks about willful misdirection of electronic messages. That is for section 11. Section 12 talks about section 12 talks about unlawful interception. Section 13 talks about computer related forgery. Section 14 talks about computer related fraud. Section 15, section 15, of which I studied. Section 15 talks about section 15 talks about theft of electronic device. Section 16 I did not store. Section 17 section 17 talks about electronic signature. Section 18 talks about cyber terrorism. Section 19 I did not store. Section 20 I did not store. Section 21 I did not store, making it 5 now that I did not store. Section 22 talks about identity theft and impersonation. Section 23 talks about child pornography. Section 24 talks about cyber stalking, of which I said before in my last video that cyber stalking you can use in the case of Attorney General of the Federation and that of Olubumi's case. Then that's for section 23, right? And section 23 is child pornography. Section 24, that's for section 24, cyber stalking. Then section 25 talks about cyber squatting. The cyber squatting is when you make use of someone else's business brand, like someone else's business logo, name, or anything related to the person's business without even giving consent before you making use of the person's business logo or business name. You just go ahead. It's an offense just making use of someone else's business name or business logo without their permission. So it's actually an offense. That is for the cyber squatting. Then for the for the section that's for section 25. Then section 26 talks about racist and xenophobic offenses. Then section 27 talks about attempt, conspiracy, aiding and abetting. Then section 28 not sure, I did not store 28. 29 I did not store 29. Then 30 talks about you sure I did not store 20? No, I did not store 28. I did not store 29. Then 30 talks about let me search my brain. 30 talks about manipulation of ATM / POS terminals. 31 talks about employees' responsibility. 32 talks about phishing, spamming, and spreading of computer virus. 33 talks about electronic cards related fraud. 34 talks about dealing in okay, it was in that was used, dealing in cards of another. Then 30, that's for 33, sorry. 30 talks about 30 talks about manipulation of ATM or POS terminals. 31 talks about employees' responsibility. 32 talks about phishing, spamming, and spreading of computer virus. Then that's for 32. Then 33 talks about electronic cards related fraud. Then 34 talks about dealing in card of another. Then 35 talks about postage or sales of card of another. Then 36 the last talks about 36 the last talks about use of fraudulent devices, attached emails and websites. So that's the offenses I was able to grasp. About 25 offenses. Then 25 offenses from section 5 down to section 36. Yes, section 5 down to section 36. So if you minus okay, section 5 down to section 36 is 31, 31, 31. Okay, 25 offenses are what I was able to grasp. Okay, thank you. You can count for yourself here. So I will just try to use this ones for my exams. So because you don't just explain what you don't just explain without making reference to the section that particular the particular problem question is dealing with. Before you have to answer a problem question, first of all you have to identify the issue of that problem. By identifying the issue of that problem, whether or not whether those are the issue, is this does it pertains to this or not? That's what the issue is talking about. Then next you have to identify the rules. That is when you start making reference to the section or the act that you want to make reference to. And you know it's already like it's already a cybercrime law exam. I don't think you have any other reference to make aside from your major reference should be from the act itself, which is the Cybercrime Prohibition Prevention Act 2015 as amended 2024. So instead of shifting or diverting to other acts like that of the advanced fee fraud, I think your main focus should be more on this particular act. It will help you to stay focused down. You can also make reference to those other acts, but it's best to because you may be talking about the elements of the offense. You don't have to start going to advanced fee fraud or the EFCC Act, the Economic Financial Crimes Act, to start making your reference. Economic Financial Crime Commission Act to start making your reference. You just have to, I think everything should be based on the Cybercrime Act itself to make your reference. It will be better off. So that's my own opinion. So if you've been able to read and to understand the offenses, you know the element of the offenses and the defenses to give, then I think you're good to go. So if you identify the issue in the problem question, whether or not, then next you identify the rule, which is you apply the sections of which you want to use. Then also you can state your case study. You can bring in your case, like you can bring in, like in the case of um, um, Raymond Akolo Julius, and that of the Federal Republic of Nigeria. You can bring in that case. I think, I don't know if I should still remember the date of the case. If it's 2021 Law Pavilion Electronic Law Report, then 54201 Court of Appeal, then from page 1 to 47, I think so, if I'm not mistaken. I'm just it's not really necessary to start stating the date of the particular case. Just note the case study, as long as it was used in class. Most lecturers don't like when you use case outside of the class, outside of the ones that were being taught in class, because they feel students always, they always assume students are likely to forge cases, and it's true. Yes, they can forge cases. You can just say in the case of Solomon versus Solomon, Solomon and Solomon, and you know that kind of case does not even exist. Yeah, Solomon and Solomon, there are so many cases of Solomon and Solomon, but it may not be pertaining to that particular narrative you're trying to give. You just forging case and you're stressing the lecturer. But if you're intending to give a case out of your advance, your extra studies of which you made, I think it's best you also state the date of the case and the available parts. If it's a Nigerian weekly law report, you state the parts, you state the page number and the rest. But if you're using a case that was being dealt in class, then you just have to state the names of the parties that were involved in that case, than rather stressing yourself to memorize the entire date like I did, like in the case of Reno and or you say versus the American Civil Liberty Union. You just state it. But if assuming this case was not given in class and you read it outside outside another place entirely, you cannot include the date. You now say in the case of Reno and American Civil Liberty Union, the case date was 1997, then 521 US 844. That is what you state. You have to be very clear. So if your lecturer is doubting you, he can be able to. But most lecturers don't have that time to start looking for the case. That is why they always they don't have that time to start searching for the case. But if you're so lucky that the lecturer is familiar with that case, your luck, you should be grateful that the lecturer is familiar with it. But you don't assume that the lecturer should know everything. Yes, that's why they always tell you to use cases that were being given in class. So that's it. So if you want to answer your problem questions after identifying the issue, okay, first of all, the method is called an IRAC method, where you state the IRAC. The I stand for issue, R stand for rule, A stand for application, C stand for conclusion. That's the best form of the best method or the best technique that is being used in answering law problem questions. So when you identify the issue, the next thing you do is to identify the rule that is applicable to that particular problem question. Then you have to now apply the rule and the instant case that was being given. Yes, then also apply your case study. You have to apply both, like you apply the rule to the application. You state the rule and you use it. I don't know how would even say it. You just apply it, right? Like for an instance, you're having an issue concerning for law of contract. You're having an issue that if the whether or not the maybe Shinedu was if the contract he had with authority press. I'm just making an instant case. If the contract between Shinedu and authority press is valid or not under contract of necessaries. So already the instant case that was given is that Shinedu is a boy of 17 years old. Yes, and now your application or your rules you were using is that of the Child Rights Act, Child Rights Act 2003. Child Rights Act 2003. So that is the act you want to use, and you already know that under section 277 of the Child Rights Act states that a child can be defined as a person under the age of 18, and Chinedu in this particular case is a child under the age of 18. And also you can also make use of the Labor Act. Yes, you can also make use of the Labor Act. Then there are other acts you can make use of, but in this particular, you've already defined. You have to first of all identify who a child is. You have to identify and make reference to a section of any particular law that states the definition of a child. You can use the Infant Relief Act. But if the case scenario that was given after the instant case was given and they said explain it by using the Child Right Act, you don't have to go to the you don't have to go and start stating the Infant Relief Act when you know the Infant Relief Act states that a child is a person under the age of 21. You start confusing yourself. So it's best to use the Child Right Act that was stated in the instant case that was given. So when you use the Child Right Act and you state in accordance to section 277 of the Child Right Act states that a child is a person under the age of 18, then you can also find a section that states that a child can be responsible if it's a child can be responsible if the contract it pertains to that of contract of necessaries. But if for an instance what the Shinedu got, maybe Shinedu is a student of so and so university, and he went to this authority press and he got about 50 law of contract textbook. He got 50 law of contract textbook, of which by right Shinedu is not supposed to get that amount of law of contract. It's the same book and he got 50 of it. It's not a contract of necessary for Shinedu because it is more than what Chinedu as a child should be should have as a student of that particular university. Highest book it should get is just one of the love contracts book of that particular author, not 50 of it. Is he planning to sell? That is, so you have to be very careful when you enter into a contract with a minor. So you state your case reference, then you said there are exceptions. If the contract is a contract of necessaries, then he will be liable. If it's a contract of necessary, that means if the contracts between the Shinedu and the authority press, if he's buying just one book and he refuses to pay, it's a contract of necessary. Yes, you can hold him liable for it. But for this particular instant case where he bought that same book for a whole 50 copies of it, it's actually not a contract of necessary. So that is it. Then you provide sections that pertains to that this thing to lay your argument right. Then while you're stating in your application, then you say you say in according to the instant case I was given, under section blah 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 state you I don't understand this thing. So you just state it, then you add in your okay, I can use also that of betrothal or child. Okay, this is Shimamanda. Shimamanda is a girl of 16 years old, and she was betrothed to a man of who was at the age of 40. It does not matter his age, as long as she is classified as a child, that contract is void. So you not just, when you identify the issue, you not just state that it is a void contract. You just say, you say if the contract between if the betrothal between Shimamanda and so is valid. That is what you first of all state in your issue. At least you should be able to identify at least one issue. Then when you state it, your rule should, under the Child Right Act, section 22 of the Child Right Act, state that any person who is under the age of 18, it's classified as a child, so therefore Shimamanda is a child. So when you state your under the Child Right Act section 22, state that any section 22 in accordance with the section 21 that stated that a child who is under a person who is under age of 18 cannot be married. You understand? Cannot be married is classified as a child because any marriage between that infant or minor is classified as void. It is void and null and void. So when you apply your rule, you state the rule, then you make a case study. You can just bring out a particular case study that was being dealt with in class. Then you start according to the instant case, blah blah blah, and Shimamanda, you state, then you put in shooking or be put state in. You know, when we write this law exam, it's only God, because at that moment when you're writing it with understanding. You're writing it, you not just write, you read the case study over and over again. So when you're applying the instant case, you don't have to restate the entire story. Just make sure that your principles are accurate, everything is perfect. Then you apply it, then you state it. If you are asked to give you just now say after your application by stating everything. I think the application there is where most students find it very difficult, but by the grace of God we do get it right. So for the conclusion, you now say in conclusion, the contract between Shimamanda and so is considered void, because Chimamanda is classified as a minor under the so and so Act, the Child Right Act, Section 20, so of the Child Right Act. So therefore, the betrothal between Chimamanda and Laura is classified as void, a void contract. So that is that. If you just get your mark very well, you get your mark. Then for that contract of necessary, you can now, there is a popular case where you can state, in the case of Nash and Inman. Yes, it was a popular case for contract of necessary. You can just state, in the case of Nash and Inman, you state it. If you state it and write it, you write it. Don't worry, you get it. It's very distinct. So for upcoming law students, just you can do it. For upcoming LLB students, not the main law, that place that used to make people to faint. Not that side that used to make people to faint though. Because when you write an exam, your lowest grade is what she's going to classify you. Like if you're writing an exam, probably you're having 6 exams to write, and you scored A, and you scored just 1 B. Is that B that they will use and acknowledge your results, not the rest A's. They don't. It's your lowest grade that will mark you. So if you're going there, you have to be very careful. If you want to make a first class, so you have to be very, you have to be very serious. You read it, read. You don't stop reading. That is if you want to make a first class. Yeah, everyone wish to make a first class. You just have to be very smart. Not just about read. Be smart. Know what you're reading. Some person may be reading and they may not be understanding. And one thing with understanding, one thing with this understanding, wisdom, knowledge, understanding, everything comes from God. It's not by human capacity. No matter how you try to, and it is also, you have to be constant in what you're doing. In your practice, you have to be constant. Before you read a topic you don't know, try to ask yourself, what is this topic all about? Write out some things. Just read the heading first of all. Write out some things. Try to check. Now ask yourself, what is this thing all about? Okay, yeah, they are asking what is cybercrime. Cyber has to do with, it pertains to that of an internet crime. It's an offense. So the little, according to my dean, Professor Tuturu, there's one thing I there was a quote he made. He said, the little knowledge you have, the little knowledge you know, that little thing you've been able to grasp, that little, even if it's just a sentence or a line, it can be able to make you to even elaborate more. You already know that it's an internet. There's an internet. There's an offense. Then expand it. You can expand your sentence and make relevant case studies. Just relevant